Hey everybody, this is Daniel O'Connor with the Bryant O'Connor Law Firm. Today I'm going to talk about a topic that can be one of the worst situations we deal with. And that's when a client of ours or a loved one of our clients develops dementia or some kind of cognitive decline and becomes mentally incapacitated and unable to handle their affairs. That's one of our most uncomfortable situations. And oftentimes these folks don't even realize their cognitive decline, and they can waste a lot of their resources. They're easily scammed. They're really in a vulnerable situation, and it's just one of the sadder things. If it's bad enough, at that point, the person can't even make estate planning documents. So they can't make, if you're unable to understand what property you have and who your loved ones are and who would get your property if you didn't do planning, technically you're not you don't have the capacity to create documents like wills or trust or powers of attorney and that kind of document. And that's a reason it's very important to do your planning early enough in life and not when it's an emergency. But frequently people incapacitated don't even want to do any documents because they don't even know that they need help. They're not able to help themselves. So what happens, worst case scenario, someone is not able to look after their best interest? Well, there's a court process for taking away that person's right to handle their own affairs, and that's a guardianship for things related to the care of the person and a conservatorship for care of their property. So if you own property and you're not able to control it or use it for your own benefit, the court can appoint what's called a conservator, sometimes called a guardian of the property, to do that for you. And again, I'm talking specifically in terms of Georgia law. These kind of proceedings go through the probate court, and it's real. Sometimes I've heard this called living probate. Most of the time you think of probate as something that happens after you die, but living probate is probably the worst kind because we frequently see families really torn up over who's going to control mom or dad's stuff or their brother or whatever. These are some of the most fought over things. I frankly don't even want to handle contested guardianships because it's sort of like handling a divorce, except you've got a person who's in the middle of it that may or may not know what's going on. What if you don't want your incapacity one day to be the subject of a court case? One option, the simplest option is, and this isn't a sure bet, but one option is to have a power of attorney. A power of attorney can take actions on your behalf. In the Georgia statutory power of attorney, you can nominate who you would want to be your conservator if you ever did become incapacitated. It still has to go through the court process. An advance directive is similar to a power of attorney, but it's for healthcare decisions, and it has elements of a living will as well. And in that document, you can nominate who you want to be your guardian if you were ever the subject of a guardianship or a conservatorship proceeding. So it's really important to have those in place so that you can nominate who you would want to fulfill those positions. But the the advance directive or the power of attorney by itself can only do half the job. You've given somebody else authority to act on your behalf and make decisions for you if you're unable to, but those documents do not take away your power to manage your property, which if you're truly incapacitated and you can't do things in your best interest, you likely do need that power taken away. A power of attorney cannot stop the principal, the person that made it, from, let's just say, giving their farm to somebody who's trying to scam them or sending money overseas. They can't stop you from doing that. They may have a little bit of leverage, but they can't completely stop you. One solution And a lot of the plans we do include these are living trust or irrevocable trust. That you can use different types of trust to meet the same purpose. Is if your property, to the extent you have property titled in the trust can, in some cases, make you the trustee. Sometimes for irrevocable trust, you may appoint somebody else. But once you become incapacitated, and I usually define that as having two different doctors sign an affidavit or a statement to the effect that you're unable to handle your affairs in your own best interest, a successor trustee is automatically appointed, and that's the person who manages your property and handles it. Now, they're required to handle it as you've previously directed. So if your trust says that if I become incapacitated, my trustee has to use the property for your best interest, and it's a little more spelled out than that, but that's the idea, then they're required to do that. And if you're not the trustee, you don't have the control over the property. So trust can be a really good way to manage incapacity situations. A will by itself, which is what frankly a lot of people have, they just have a will, which does serve an important function, but it does nothing while you're alive. It doesn't provide for anything for incapacity. It has no effect. A power of attorney can do part of the job, an advance directive can do part of the job, but a real plan for incapacity includes all these different elements, and typically including a trust if you really want the best plan, and to really manage that situation, to ensure your property is used as you want. Powers of attorney usually give somebody the power and spell out what all powers they have, but they typically don't spell out how you want the property used. Do you want to remain in your home? Do you care what kind of nursing facility you're put in? You know, and a power of attorney doesn't typically spell those things out. So just keep that in mind. Estate planning is not just naming who you want to get your stuff. It's not just beneficiary designations. It's planning for yourself while you're alive too. And that's why I gave this talk today, because a lot of people think of planning as just what happens when they're dead. But a big part of planning is getting organized while you're alive, and also having a plan for your life. And planning for incapacity is part of that. So I hope you learned something today, and we'll follow up soon.